Good morning, everyone. Welcome to our webinar titled Calculating Quantum for a Common Law Damages Claim. My name is Hannah Staunton. I'm a lawyer at WorkCover Queensland, and I'll be your host for today's webinar. Before we get started, I'd like to acknowledge and pay respect to Queensland elders, past, present, and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters, and community. Today's webinar will run for approximately 1 hour with some time for questions at the end. If you need to leave a bit earlier, this session will be recorded and we'll send it out to you by early next week with today's slide presentation. It will also be uploaded to WorkCover Queensland's YouTube channel and on the WorkSafe website. During today's webinar, please feel free to submit any questions using the panel on the right-hand side of your screen. If timing goes all according to plan, we will aim to answer some of your questions at the end of the main presentation. And just a reminder that questions answered and advice provided today by WorkCover and HopgoodGanim lawyers is general information only and should not be taken as legal advice. I'd like to introduce our guest presenter for today's session. Anna Hendry is a partner of the Insurance and Risk team at HopgoodGanim lawyers. Anna acts on behalf of major public liability insurers, workers' compensation insurers and self-insurers, compulsory third-party insurers, and professional indemnity insurers. Anna has been a WorkCover Queensland panel solicitor since 2011 and approved delegate solicitor since 2008. She has also represented WorkCover Queensland in various proceedings, including disputes regarding statutory entitlements, disputes regarding premium calculation, and personal injury claims. We are really appreciative to Anna for presenting for us today, particularly given her extensive involvement with WorkCover over many years. Anna, over to you to start the presentation.
Thanks, Hannah, and it's lovely to be here today. When you contacted me to speak today and told me that you'd like me to speak about quantum assessments, I was really pleased. The reason for that is that as a panel lawyer, I'm often the first person who an employer speaks to after they receive a notice of claim. And in, I would say, 98% of cases, I'm asked two questions first up. Firstly, am I covered by WorkCover for this? And secondly, how much is the claim worth? Those who've had the experience of receiving a notice of claim will know that it contains a quantum assessment within it, which has been calculated by the claimant solicitor. And down the bottom right-hand corner of that quantum assessment is a total figure. That total figure is generally fairly high, and I can understand why an employer receiving a notice of claim can be a bit on edge about what the claim might be worth. Unfortunately, answering the question of how much a claim is worth is not as simple as knowing how much another claimant received for a similar injury. Much like cooking, a quantum assessment is part science and part art, and little tweaks to the ingredients can make a big difference to the result. So my goal today is not to turn you all into master quantum assessors. After all, I don't want to do myself out of a job. But I would like to give you a basic recipe for a quantum assessment and provide you with some of the lingo so that next time you're talking to your WorkCover lawyer, you can better understand what they're speaking to you about. To do that, we'll run through a couple of things. Firstly, the ingredients of a quantum assessment. That's the information that I, as your panel lawyer, need in order to be able to produce an appropriate and accurate assessment of quantum. Next, we'll talk about the components of a quantum assessment. And these are 6 components, 6 courses in the meal that is quantum. We'll round out that discussion by talking about discounting and apportionment and the statutory refund. Those concepts are important, not in calculating the quantum so much, but in understanding how we might negotiate a resolution. So if we turn firstly to the ingredients of a quantum assessment, I should start by saying that the objective when undertaking a quantum assessment is to place the worker as nearly as possible in the same position as if they had never been injured. It's assessed on a once and for all basis, so it needs to cover off contingencies like loss of job and possible future surgeries. This is the plaintiff's one opportunity to be compensated for the effects of the injury. In order to place the worker back as closely as possible in their pre-injury position, we need information about what that position was and what their position is now. This is the ingredients of the quantum assessment. The first ingredient is personal characteristics, and that might include characteristics such as age, qualifications, English speaking status, criminal history, compensation history, and return to work status. As we go through the quantum assessment process today, it will become clear how each of those attributes might be included in the assessment of quantum. The next ingredient is work history, and that is in terms of both historical income, pattern of employment. We may have a claimant who has worked in the same job for 15 years, or we might have a claimant who typically is a casual worker who stays in positions only for short periods of time, with perhaps some periods of unemployment in between. We'd also look at work experience in other roles and industries other than the pre-injury role, and perhaps performance management that was occurring in the pre-injury role. The third ingredient is medical history, and that medical history might relate to other similar injuries that occurred prior to the subject injury, or unrelated serious injuries or conditions that might affect the claimant's likely working life or likely life expectancy. And that will include psychiatric history as well. Expert medical evidence is the next ingredient. This consists of medico-legal reports from specialists regarding the relevant injury, and can also include medico-legal reports regarding those unrelated serious conditions that might affect working life or life expectancy. Typically, we don't have this information when the notice of claim is first served. We might just have some reports from the statutory claim and perhaps a report served by the claimant if they've attended their medico-legal reviews before compiling the notice of claim. And the final ingredient is industry-specific information. That is perhaps information regarding typical retirement age in that particular industry, downturns in the industry, planned redundancies or pay rises, and perhaps different superannuation entitlements pertaining to different industries. For instance, teachers and government workers typically receive greater superannuation contributions from their employer. So once we've got all of the ingredients together, it's necessary to consider how we'll apply those ingredients to come up with the quantum assessment. Rather than trying to tackle the whole assessment in one go, a quantum assessment is broken down into 6 components, much like a 6-course meal, with different ingredients required for each course. Typically, as you can see from the table, I would assess a low range and a high range for each of those components. And the reason for that is that the evidence is often divergent. And so the low range may reflect the employer's best case scenario, whereas the high range may reflect the claimant's best case scenario. For those of you who have received a notice of claim in the past, you'll recall that it includes a notice of assessment, a quantum assessment, which is set out in pretty much this same format, except that it doesn't include a range. That's because it's ultimately an offer made by the claimant to settle the claim. So let's go through now one by one the components of a quantum assessment. The first is general damages, and many of you will know this head of damage as pain and suffering. The ingredients in calculating general damages is pretty much just the expert medical evidence. The calculation of general damages is now regulated by legislation, so this head of damage is really more science than art. The only real variation in assessment occurs where there's a big difference in opinion regarding the various medical experts. In order to calculate the general damages, we need to have the medical diagnosis and the DPI, and that will be set out in the various medical expert reports. Now, this is where the lingo comes in. So the DPI is degree of permanent impairment, and that will be expressed as a percentage. So typically you would have an expert report produced by the claimant's solicitors or commissioned by the claimant's solicitors, and an expert report commissioned by the work cover solicitors. And they may have divergent views, with perhaps the claimant's expert having a slightly higher DPI than work cover's expert. Once you've got that information, you then need to go to the Workers' Compensation and Rehabilitation Regulation, which sets out a long list of all of the different types of injuries that you could possibly imagine. You locate the correct item within that list. So for instance, your claimant might have an injury falling within item 91, which is a moderate lumbar spine injury. That item attracts a range of ISV, so that's your next piece of lingo. The ISV is an injury scale value. It's a number from 0 to 100, and it corresponds with a monetary amount. Once you've worked out which item is relevant and what the ISV range is for that item, it's then a matter of deciding where within that range the claimant falls. And again, it's necessary to have regard to the expert medical evidence, and in particular to the DPI. You can decide then perhaps on a range within that range, and that corresponds to a monetary value. We've actually already had a question sent in relation to how to calculate general damages for multiple injuries. And the question is there an amount awarded for each injury? This is specifically provided for under the Act. There's a process by which you pick the item number that attracts the highest possible ISV. So if we take someone who has an elbow injury, a shoulder injury, and perhaps a head injury, and we work out which item number relates to each of those individual injuries, and then decide which one attracts the highest maximum ISV, it's likely in this case to be the head injury. That would be what's called the dominant injury. It's then necessary to consider whether the maximum ISV for that dominant injury is sufficient to compensate the person for the multiplicity of those injuries. Or perhaps, if it is not, you could apply an uplift. And that's part of the jargon that you'll hear work cover lawyers talking about, or plaintiff lawyers talking about, in relation to multiple injuries. So an uplift is an allowance above the maximum ISV for that dominant injury. And it's usually not more than 25% from the top of the range. Before the legislation was enacted, we undertook a common law assessment, which required considering judgments involving similar injuries. So you would have to go and find other cases involving, for instance, lumbar spine injuries, and see what those plaintiffs were awarded in order to determine the likely pain and suffering award. It's interesting to note that the legislation has generally resulted in lower damages awards for the more common types of injuries. And just as a little example for you, in the matter of Husband against Hikari number 42 Proprietary Limited, that was a 2010 Supreme Court case, Justice McMeekin noted that neck and back injuries at that time attracted an award of $50,000 to $55,000 in less serious cases, and $80,000 in more serious cases, perhaps with a component of psychiatric decompensation. He awarded the plaintiff in that case $55,000 for general damages. By contrast, I've undertaken an assessment using the legislation, and I consider that the plaintiff in that case would have fallen within item 91, which is the moderate lumbar spine injury. That item attracts a range of 5 to 15 for ISV, and having regard to the medical evidence, I consider she would probably fall between a 10 and a 15, which in today's value equates to an award of $16,885 to $27,665. So you can see that the award that's available under the legislation is significantly lower than what she was awarded on a common law basis. If we turn now to the next head of damage, which is past economic loss. Now, this is loss of income from the date of accident to the date of settlement or judgment. It's quite often a straightforward calculation of weekly income by number of weeks between the incident and the settlement, less any actual income during that time. I should note that weekly benefits paid by WorkCover Queensland are not considered to be actual income for that calculation, and that's because the weekly benefits are refundable from the settlement, but we'll come to that a little bit later. Where things can get complicated with this calculation is where there are any arguments about the true period of incapacity, the true cause of the incapacity, or the claimant's likely income during that time but for the incident. So I'll give you some example of the types of disputes that might arise. Firstly, there might be a dispute about the period of the incapacity where the claimant says they were unable to return to work, but the medical evidence says that they should have been able to return to work from a particular date. So in that past economic loss period, there will be a short period that is in dispute. That scenario is fairly closely linked to a concept that we lawyers call failure to mitigate. That is, we allege that although the claimant may not have been able to return to their pre-injury role, they had some capacity to work and have failed to mitigate their loss by exercising that capacity, be it in a different role or in part-time work. Another dispute can arise where the work-related injury was a temporary aggravation of a pre-existing condition. Usually the medical expert will give a time when the work-related symptoms ceased and the pre-existing condition took over. We would argue that the loss flowing from the work-related condition ceased at that point, so there would be part of the economic loss period that is in dispute. And finally, disputes can arise about the claimant's likely income but for the injury. It may be that the claimant had not been in that job for very long, and so their average income in that role is not necessarily indicative of their usual earning capacity. Or it might be that they were under performance management before the injury and were likely to be terminated at some point during that past economic loss period. Or it might be that there was a mass redundancy of their role during the economic loss period, and we say that part of their loss is due to that and not because of the injury. So you can see how what looks at first glance like a very straightforward calculation can have shades of grey. Past economic loss also includes past loss of employer superannuation contributions. And of course, there can be variations in that figure where a claimant works for an organisation that makes higher than usual contributions. Usually that's not the subject of any great dispute because typically those higher contributions are provided for in the employment contract. The other item that's included under the heading of past economic loss is Fox v Wood. Now, that is the name of the case that established this principle. Fox v Wood damages are the difference between the tax on the plaintiff's taxable income and the tax on the plaintiff's taxable income less the refundable workers' compensation. It's basically a tax adjustment to ensure that the claimant is placed in the same position as if they had not been injured and hasn't had to pay extra tax. There's almost never any controversy regarding that calculation. It's very straightforward. So that's past economic loss. If we move now to future economic loss, this is typically the largest damages component, and it's the one that lawyers spend the most time arguing about. It's a comparison between what a claimant might have earned had they not been injured and what they might still earn. There's a little bit of crystal ball gazing with this one, and it includes all of the ingredients of the quantum assessment. So personal characteristics, work history, medical history, expert medical evidence, and industry-specific information, all in different amounts. So if we start firstly with the two ways that we can assess future economic loss, we can use a weekly calculation or a global award. There is a preference for using a weekly calculation, and the weekly calculation, get ready for all of the lingo, is notional earning capacity less residual earning capacity until retirement age, discounted on the 5% tables, and discounted by a percentage for contingencies or vicissitudes. So if we unpack that now concept by concept, the notional earning capacity is what we say a claimant would have earned net of tax each week for the rest of their life but for the incident. So here we're considering personal characteristics and work history. The residual earning capacity is what we say they are now capable of earning. Here we're looking at expert medical evidence about the occupations the claimant is now suited to, or perhaps the amount of work that they're suited to. There may be experts who say they can continue on in their pre-injury role, but that they're now only suited to part-time work. Or perhaps the medical evidence is that they're no longer suited to their pre-injury role and they need to move into a lighter role. The next relevant concept is retirement age, and that seems pretty straightforward because generally in Australia the retirement age is 67. However, there are often disputes about likely retirement age, particularly where the work is very heavy. So for instance, average retirement age can be an issue where we might obtain industry-specific information, and we see that a lot in mining claims. Personal characteristics can also come into play with this ingredient. It's not uncommon to find a claimant who says that due to a particular financial commitment, they had intended to work past the age of 67. The next concept is the discount on the 5% tables. Now, that's not something that you particularly need to worry yourself about, but it's useful to understand why it's being applied. It's an actuarial discount that's applied to take account of the present value of a future loss. So if I give you $1 today, it's worth more than $1 in the future. I'm compensating a future loss. So we apply this discount to prevent overcompensation. And the use of the 5% tables is provided for under the Act. The next type of discount that's applied is a discount for contingencies or vicissitudes. Those are things that might happen in the future to negatively affect the claimant's earning capacity, independent of the subject incident. There is a somewhat standard discount of 15%, but there might be a departure from the standard, either higher or lower, depending on the claimant's personal characteristics, medical history, or industry-specific information. For instance, you might have a claimant quite close to retirement age who attracts a lesser discount, less than the standard 15%, because there are only a few years for the contingencies to actually arise, so the chance of them occurring is lower. Conversely, a younger claimant might attract a higher discount. We might also apply a higher discount for a claimant employed in a finite or uncertain industry like mining, or for a claimant with another serious health condition that's likely to impact on their earning capacity. Now, it's important to note with that type of factor that there would need to be expert medical evidence on that point, not just a bald assertion that someone with a cardiac disease, for instance, might not work for as long as another claimant. I have certainly run cases where we've had expert cardiologists give evidence about the likely impact of a cardiac condition on the ability to work to age 67. I've also had one where we had a general physician give evidence about the impact of type 2 diabetes and psoriasis, very severe psoriasis, on the ability to continue working to age 67. So that's the weekly calculation method, and you can see that it's called a calculation, but there's really quite a lot of room for dispute because there are sort of shades of grey within each of the components of that calculation. The other method is a global award, and this is applied where loss of earnings are unable to be precisely calculated by reference to a weekly loss, and where the court is satisfied that the worker has suffered or will suffer loss, having regard to the person's age, work history, actual loss of earnings, any permanent impairment, and any other relevant matters. And that comes directly from section 306 J of the Act. That section also states that a court must set out the assumptions and methodology for the award, which of course provides transparency for the basis of the award. So this is where the next set of jargon comes in. We often talk about a global award being to compensate for restricted occupational pool. That's the idea that a worker was in a light or sedentary job, but had experience in manual work and could have fallen back on manual work if necessary, but now can't due to the restrictions associated with the industry. So we talk about their occupational pool, or the range of occupations that might once have been open to them, as having been reduced or restricted. Another justification for a global award is disadvantage on the open labour market. This is the idea that a worker will be less likely to be chosen for a role over uninjured peers who are competing for that same role. And this is all sort of tied up with the idea that a worker or a job applicant can be asked for information about their physical capacity to undertake a job, and that perhaps if they answer accurately in relation to their physical restrictions, they may not be considered for that role. I should also note that the onus of proof regarding residual earning capacity and in relation to the effect of pre-existing conditions rests with the defendant, and it can be quite a high bar to jump. So if you're involved in a claim and you attend the compulsory conference where there are submissions made by the various solicitors regarding those aspects, you'll often see that there's quite a lot of dispute about what can be proven in that regard. So if you move on now to the next head of damage, which is past special damages, this is another one that is quite close to being a calculation. It relates to what the plaintiff has actually spent on medical, pharmacy, treatment, travel, those kinds of things. You'll see that I have listed Medicare benefits there. That's because Medicare is refundable from any settlement or judgment, so it has to be included, otherwise the claimant would be disadvantaged when it was then refunded to Medicare. The only dispute that we really see in relation to past special damages is a dispute regarding whether the treatment was in fact required, and perhaps whether it was required for the work-related injury or for some other injury. So, for example, you may have a claimant who has received some unusual type of treatment that is perhaps not clinically justified for the injury, and there may be a dispute about whether it was really necessary. And the other one is where we've got a claimant who has a pre-existing condition. There may be a dispute about whether the treatment was required for the work-related injury or for that pre-existing condition. So then, again, although it looks like we just add up all of the receipts, sometimes there can be a dispute about whether a particular treatment is compensable. Which then brings us to future special damages. This is future treatment costs, so it'll include treatment, surgery, aids and equipment. And in the case of some more severe injuries, it can include house and vehicle modifications. Again, there can be disputes about what treatment will be required. Obviously, the expert medical evidence comes into play here, and the item that is often hotly contested is the need for future surgery. It's very difficult to predict whether surgery will be required in the future and when it will be required. And so that's an item that is hotly contested. There are two types of discounting that are applied in relation to future special damages, much like the discounting that we talked about for future economic loss. So the first type of discounting, and this is actuarial discounting, is discounting for future value. That discounting applies, like with the future economic loss, to the calculation involving a weekly expense. And again, it's to ensure that if I give you $1 of compensation now, it's worth more in the future. And so it's slightly less that I give you now. The second type of discounting is a discounting for deferred future value, and that applies where there's a one-off future expense like surgery. So again, you don't need to know the ins and outs of how that works, but it's quite useful if your solicitors are talking to you about it to understand why that's being applied. So the final head of damage that we'll talk about today is care. Now, this includes past and future care needs, and it can include services like mowing and cleaning, as well as your more standard nursing care type arrangements. The entitlement to claim care expenses is governed by the legislation. There's no entitlement to a loss for care where it relates to gratuitous care, that is care that's provided for free. So typically we might see a husband who is injured and he says, well, I used to do pre-injury, I used to do the mowing and the gardening and wash the car, and those jobs have been taken over by my wife or my child or my friend, and they do those things for me for free. The worker in that instance is not entitled to compensation for the commercial value of those services. However, if they have paid for that type of care on at least one occasion since the incident, they may be entitled to compensation for the future cost of that care. So what we typically see is claimants paying for one lawn mowing service and then claiming that one receipt in the past, but claiming the ongoing cost of that into the future. Again, there will always be a dispute about whether that care is truly required and whether the need for that care is justified based on the subject incident or whether it relates to some pre-existing condition. And that's, again, where the expert medical evidence comes in. So that's the end of your quantum assessment. You can add up all your numbers and come to a figure down the bottom, as it does in the notice of claim. Flowing on from a quantum assessment is the idea of discounting and apportionment. And these concepts are more important when you're looking at a negotiation and what we might look to offer to resolve a claim. So they're more linked in with concepts of liability, but because they're likely to be concepts that your solicitor would talk to you about when discussing quantum and discussing negotiations, I think it's helpful for you to understand those concepts now. So discounting is typically applied when there's a risk that the claimant will not prove liability against the employer, or where there's a risk of finding of contributory negligence, that is, that the claimant contributed to their own injury by some negligent action. Whereas the concept of apportionment applies where there are multiple tortfeasors or defendants who might be liable for the claimant's damages, and there's a kind of divvying up of the damages amount between those defendants. Discounting and apportionment are typically done with reference to a percentage, and so I'll show you shortly how that sort of ties in with the calculation. The discounting for risk and also apportionment between defendants is really a whole nother topic, which I won't go into further today. But if that's something that you're interested in, please let WorkCover know and they may be able to run a webinar for you on that topic. So if we look now at how the calculation might proceed, you can see we've got the total gross damages, having added up all of those 6 heads of damages that we've been through. And then in this example that I've given you, we've got an apportionment of liability to another defendant. In this example, a host employer. This is a labour hire claim, my hypothetical labour hire claim. So in that one, we've apportioned 75% of the damages to the host employer. And then we come to a subtotal, which is the gross damages after apportionment. Now, this is the important bit to understand when you're speaking to your WorkCover lawyer, is the difference between gross damages and net damages. So the amounts that were paid in weekly benefits, that is the amounts compensating time off work and also the medical expenses paid by WorkCover, are all refundable to WorkCover from any damages award or settlement. So we talk about the net damages as being the total damages less that statutory refund. And you can see on that example there, we've got the total gross damages after apportionment, and then we deduct the refund to arrive at the net damages. In this example, because we have an apportionment to another defendant, we end up with a scenario where on the low range, the net damages is a negative figure. That means that if we settle for the low range of this quantum assessment, WorkCover could expect to receive a refund, a nice check in the mail, for $2,500 from that other defendant. Whereas if we settle on the high range, WorkCover could expect to pay an extra $10,000 on top of the statutory benefits that have already been paid. So I know that talking about gross and net is something that you'll get to with your solicitor when you kind of get to the pointy end of what will we settle for. And it can be quite confusing if you're not talking about the same figures. So that's how that concept works. So that's really the end of the quantum assessment.
Too easy. Thanks, Anna. Thanks, Anna. We might just break for a minute or so to let Anna have a drink of water and also just to gather of thoughts in response to the questions that have been sent through during the webinar. So we will be back in a couple of minutes. Thank you. Awesome. Thank you for being patient with us. I'm just going to hand over to Anna now, and she's going to read the question out that was submitted before answering it.
Thanks, Hannah. So the first question is, would it reduce future economic loss if WorkCover supported retraining or further education? And that's a really good question. And it's actually a question that I get asked a lot as a panel solicitor, also in conjunction with, would it reduce future economic loss if the employer supported return to work? The answer is absolutely yes. Obviously, if we have a claimant who has managed to return to work, whether that be in their pre-injury role or in some new role, whether it be part-time or full-time, it all serves to reduce the economic loss that that person will experience. Of course, WorkCover has its common law return to work program. Part of that program is that a representative from WorkCover Queensland will work with the claimant on retraining and re-education during the common law claim. And that's an adjunct to the work that will already have been done during the statutory claim. That program, of course, relies on the willingness of the claimant to be involved. As a panel solicitor, I would always encourage the claimant via their solicitor to be actively involved in that program. It benefits the claimant, it benefits the employer, and overall produces a great outcome. The second question that we've got is, will the court usually accept the claimant's or WorkCover's expert medical evidence regarding the worker's capacity for work? And that's a tricky one because it probably is on a case-by-case basis. If a matter proceeds to trial, what happens is that typically the claimant will have an expert witness, and so will WorkCover, the employer. And that the evidence in chief, so their primary evidence, is given by way of their report. So the report is submitted to the court, the judge will have read the report, and then the other side has an opportunity to cross-examine the medical expert, and this is usually done over the phone. So they'll appear in court by phone, and if it's WorkCover's report, then the plaintiff's barrister will have an opportunity to cross-examine on that report. That evidence is considered by the judge. There'll also be an opportunity for re-examination, and it's often how the expert evidence presents in court that sways the judge's mind as to which expert should be accepted. The times that we see an expert just being absolutely shot out of the water is when their evidence seems to be so far removed from reality. So for instance, you might see an orthopedic surgeon saying the claimant has sustained a very serious leg injury, but I think he'd be fine to go back to working in a mine. And that is what happened in a case that I ran. And the court just said, look, that evidence is so far removed from the reality of what it is like to work in a mine that I couldn't possibly accept that evidence. But otherwise, if the two experts have more moderate views, then it's simply down to the court to decide which expert they find more compelling. And I suppose we're not able to tell you whether a court is more likely to go one way or the other overall. We would have to look at the two pieces of evidence. So we've had a couple more questions while I've been talking. One is a question regarding the statutory refund. So the question is, does the stat refund include the PI amount contained in the notice of assessment? Now, that will depend. So if it's an injury that is under a 20% whole person impairment or degree of permanent impairment, the claimant, in order to bring a common law claim, will not have accepted that PI amount, so they haven't received it. So it certainly won't be included in that statutory refund because it's not something they've received anyway. If the injury was over 20% and the claimant was able to accept that PI offer and still bring a common law claim, then yes, the PI amount that's contained in the notice of assessment will be part of that statutory refund. And that can be quite large, as you know. So, and that can have a really interesting effect where we have multiple tortfeasors, like the example that I've given you, and we have this apportionment scenario. If there's been a really high PI amount, then you can see that WorkCover could stand to receive quite a large refund from that other respondent. Fortunately, we don't see too many injuries over 20%, so that scenario doesn't come up too often.
Well, good. We might cut it there for today. Big thank you to Anna for taking the time out of your busy day to present to our valued employers. I really think that your presentation will hopefully help employers out there listening to more clearly understand how a panel of lawyers assess the quantum value of a common law claim. So that's all from us here today at WorkCover. More details about next webinar will be sent out shortly. So please stay safe and have a great day.